Hello, everyone, and thank you for attending today's webinar. Before we begin, we want to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it'll be answered later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links you may find useful. You can find additional answers to some common technical issues located in the help widget, also at the bottom of your screen. Today's event is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to receive full credit. We value your opinions and appreciate your participation in the course.
Hello, everyone, and welcome to the July installment of Being Resourceful, Thompson Colburn's HR Law webinar series. I'm Emory Moore, a partner in our Chicago office, and I'm joined by my colleague, Hannah Lustman-Rodriguez, a superstar associate based in our St. Louis office. Today's session is focused on a challenge every HR and legal team eventually faces: how to respond when an employee crosses the line, whether by misappropriating trade secrets, stealing clients, or engaging in other damaging conduct. We'll walk you through scenarios inspired by real cases we've handled and break down how to respond strategically before the wrong move turns a manageable problem into a business crisis. As mentioned, I'm Emory. I focus my practice on all aspects of labor and employment law with a particular emphasis on corporate espionage. Put simply, I help employers when employees or competitors cross the line and try to harm the business. I also represent companies defending against those kinds of claims. I've been doing this for a while now, and one thing I've learned is that what happens in the first 48 hours can make or break a case. So I'm excited to be here with Hannah today to walk you through those critical early stages.
Absolutely. Hi, everyone. As Emory mentioned, I'm Hannah Lustman-Rodriguez. I often work with clients right at that decision point. My practice includes employment counseling and litigation across a range of industries, and I regularly partner with in-house legal and HR teams to navigate sensitive workplace issues. A big part of my work is focused on preventing problems before they escalate, but when they do, I help clients manage legal and reputational risks that follow. So we want to start out with a roadmap for the scenarios we're going to be discussing today. We've structured today's session around 5 scenarios that we frequently encounter in our practice. Each illustrates a different type of employee misconduct or organizational risk. We'll begin with the Friday afternoon call, where timing and triage are critical. Then we'll move to scenario 2, the case of the phantom evidence, which focuses on investigating the threat. From there, we'll tackle scenario 3, the case of the moonlighting exec, a scenario where legal and business interests collide. Next, scenario 4, the case of the poached playbook, which raises questions about pre-litigation strategy. And finally, we'll discuss the case of the untouchable exec, highlighting common pitfalls and how to avoid them. Throughout each scenario, we'll introduce strategic tools that you can use to guide your internal response. Our goal is to equip you with a repeatable, strategic approach that you can apply immediately when a threat arises.
Okay, so scenario 1. It's 4 p.m. Friday. It's 95 degrees. You're wrapping up your week, getting ready to enjoy the weekend. You hover your mouse over the shutdown button on your laptop, and then you receive an email marked high urgency. The subject line, need you ASAP, serious employee issue. It's from your CEO. He just got off the golf course where a trusted contact told him one of your company's employees has started a competing business and is reaching out to the company's clients. And he's planning to resign Monday after he's poached as many relationships as he can. What do you do? Do you call your IT department and immediately instruct them to begin pulling access logs? Do you tell the CEO, hey, I'm heading out, I'll look into it Monday? Do you call outside counsel? Do you call the employee directly and ask them, hey, what's going on? Do you terminate them immediately? Or do you take other action? Let's take a quick poll. I want you to choose the option that most closely represents what you would do in the scenario, not what your policy says, but what you would actually do. And I'll say this while you're giving your response. I've seen multiple different courses of actions from cities and legal teams in response to this. So there's not one size fits all.
We'll give just a little bit more time for folks to select their first move.
Okay, we have around 60%. Okay, very, very interesting split here. We're seeing kind of an even split between call your IT department and start pulling those logs and call outside counsel. And then we're seeing a substantial amount of take other action. Honestly, I think take other action is a great selection in this choice. The other ones are good options as well, but they're all a part of your broader strategic goal. Most of these moments don't fit neatly into one bucket. So the real question is really what kind of action and in what order you're going to take that action. That's where our decision matrix comes in. So let's talk about how we actually make the call in situations like that Friday afternoon scenario. This is the decision matrix we'll be using throughout today's session. You'll see us return to it as we apply it to each scenario. The key idea is not all instances of employee disloyalty warrant the same kind of response or urgency. We encourage clients to evaluate 3 core factors before deciding how to respond. First, business impact. How serious is the disruption to operations, clients, leadership, or revenue? Second, legal exposure or risk. What types of claims and damages are at play? Which is, what can you legally do about it, and is the available relief really worth it? And third, evidence strength. Are you dealing with solid proof or just suspicion and rumor? The tipping point is when you have all 3: significant business impact, meaningful legal exposure, and strong evidence. That's when it's time to act quickly and decisively. But if one or more of those factors is uncertain or weak, it may be smarter to pause, investigate further, or recalibrate your strategy before escalating. So rather than reacting based on instinct or pressure, this matrix helps teams slow down just enough to make smart, risk-aware decisions. We'll model how that works in each of the scenarios ahead. Now that we've introduced the decision matrix, we want to add another layer to help guide your response. These are 4 strategic filters we encourage clients to consider before deciding how to move forward. The first is timing. Is a delay likely to cause harm or data loss? In some cases, you may have the luxury of time to investigate. In others, even a short delay could cost you critical evidence or create a legal disadvantage. Next is forum. Do you have a jurisdictional advantage or risk if litigation becomes necessary? This may affect whether you engage pre-suit, for example, issuing cease and desist letters, or act quickly to secure your preferred venue. For example, oftentimes we see that a claim could be brought in California or it could be brought in Delaware. If I'm on the defense side, oftentimes I want to file a declaratory judgment action to get my preferred venue. If you're on the plaintiff side, you want to be aware that that potential race could be at issue. The third is leverage. Will a more measured response allow you to preserve future options or protect a business relationship? Sometimes showing restraint can give you more control than immediate escalation. And finally, consider visibility. Will the action you take become public, either internally or externally? If it does, are you ready for that? Think about the message it sends to your employees, leadership, or even your competitors. Do you want to be known as an employer that is overly litigious against employees? These filters are not about legal rules. They're more about strategic alignment. Just like the matrix, we will apply them to the scenarios that follow. With that foundation in place, I'll turn it over to Hannah to walk us through our next scenario. This one shows how quickly things can turn poorly.
Thanks, Emory. The next scenario is one we're calling the case of the phantom evidence. It highlights how a company's poor diligence led to an embarrassing misfire. In this case, a healthcare provider filed a federal lawsuit against a former employee, alleging that he had misappropriated confidential patient information to help launch a competing clinic. The allegations included claims that he accessed and downloaded sensitive medical and billing data to support this new venture. The lawsuit was filed before the healthcare provider attempted to discuss the matter with that former employee. However, after filing suit, the plaintiff struggled to produce evidence that the physician had actually taken or misused any protected information. Instead, the information was either anonymized photos of medical conditions or stale, outdated information that was of no benefit and was only inadvertently retained, not anything that was actually used to compete. The internal investigation appeared to have been minimal prior to initiating litigation. As the case progressed, it became clear that the claims were not supported by evidence. Having spent a large sum of money filing a lawsuit, though, it was difficult for the company to admit failure and walk away. Instead, they dug their heels in, intent on proving themselves right, but to no avail. The lawsuit not only strained the provider's reputation, but also could have been resolved, or maybe even avoided entirely, through a candid pre-litigation discussion. So before you escalate, file a lawsuit, or take disciplinary action, you must conduct an internal investigation. The goal here is to be quick but effective. You don't need a full-blown forensic audit in every case, but you do need enough reliable information to make sound decisions. Speed matters here, but so does credibility. You need to know what evidence to gather first. That usually starts with access logs, email activity, file downloads, and any communications that you deem relevant. If business or personal devices might be involved, you'll want to figure out what you're legally and practically able to review. And don't forget to talk to people, meaning colleagues, supervisors, your IT department, anyone who may have context. You should also always review employment agreements, policies, handbooks, and other key documents. These documents help define your rights, the employee's obligations, and your potential legal claims. If there's a confidentiality policy, a non-compete, or even just language in a code of conduct, you'll want to know that before making any decisions. This early due diligence and investigation is really what sets the stage for everything that follows. So, as I mentioned, the goal with this initial due diligence and investigation phase is to be quick but effective. And that effective component can apply to who you involve in your investigation early on. So internal teams are often under pressure to act fast, especially when it feels like trust has been broken. But if you rush to take legal action without gathering facts or getting the right legal input, you can risk triggering high stakes litigation that becomes hard to walk back, just like the scenario we just discussed. This is where the right outside counsel can serve as a moderating force. Not just someone who checks the boxes, but someone who understands the nuances of employee competition, data misappropriation, and fast-moving decisions that come with those kinds of claims. Your regular HR or employment counsel may be excellent at day-to-day issues, but when the situation involves potential IP theft, confidential information, or restricted covenants, you may need a team with experience in both employment law and intellectual property litigation. So let's go back to the phantom evidence case for a moment. The company might have avoided the misfire if their legal team had asked two basic questions up front. First, was the information at issue even protected under the law? And second, was there a faster, lower risk way to resolve the issue without filing the lawsuit? Having the right legal partner early on often makes the difference between a strategic resolution and an expensive public mistake. So let's pause to discuss sort of the initial evidence gathering phase and what kind of evidence you should be gathering right away. Specifically, let's take a beat to talk about devices. The company will almost always control an employee's email, but what about every other digital component we're carrying around with us every day? So phones, tablets, and computers. So to be clear, it is never advisable to intermingle devices. It's rather recommended that you be separating your business devices from your personal devices. You should also be taking steps to ensure that you get employees' business devices back prior to their departure from the company. And it can also help shore up here if you have a policy that requires the return of those devices at the end of employment, one that's acknowledged at the outset of employment when the device is given to the employee for use. You should maintain a roster of every device the company loans out to employees, and that roster should have serial numbers and other key identifiers, specifics about those devices. If you have concerns about a departing employee, or if you're already aware of a problematic behavior, you might consider engaging a vendor to have the employee's devices imaged before anything else can happen. Let's also talk about interviews that you may want to conduct in this initial due diligence phase. So I have here coworker interviews, but that's a pretty broad category. So you may want to interview the employee's manager, the employee's key direct reports, your IT department. If you're concerned that a key witness is departing, you might consider getting a signed statement from them. For each witness, you should be keeping in mind who is interviewing that employee and whether or not attorney-client privilege potentially applies in the scope of that interview. That can also play into your decision about whether or not in-house counsel, outside counsel, or potentially even your human resources department interviews that employee. And who you decide to interview may also depend on the kind of protectable interest that's at stake. You likely need to talk to your business leaders or your IT department and maybe even an IT outside expert to get some more critical facts about that. So next in due diligence, let's talk about consulting those key documents. First, your employee handbook. That handbook may speak to many of the key issues that arise when an employee is disloyal. So that means confidentiality, competition, etc. Even still, the handbook is distinct from an individual agreement between your organization and the employee on these issues. So for instance, confidentiality provision in your handbook is different than a confidentiality agreement, and they provide different levels of protection. A handbook is more helpful to show knowledge of company policies and values the company's values rather than helpful in binding the employee to something specific. The handbook itself is almost certainly not a contract, even if the employee has acknowledged it. So what about those contracts, specific agreements? Not all agreements are created equal. They should be drafted by attorneys, not business professionals, and certainly not by artificial intelligence or a web program like LegalZoom. Agreements are not one size fits all. They vary by industry, company, position, compensation level, protectable interest at issue, and many other factors. In your initial investigation, what do you want to confirm when you're looking at these agreements? Well, exactly what the relevant agreement says, who is a party to it, what law governs, whether that agreement is enforceable, and what, if any, remedies it provides you. For instance, does the agreement provide attorney's fees to a party that has to initiate litigation to enforce the agreement? A reminder here that these agreements relate back to the strategic filters that we touched on earlier, one of those strategic filters being forum. Maybe you have a jurisdictional advantage or disadvantage because of a choice of law provision or the law that otherwise applies to that agreement. Let's pause briefly for the first secret word today. The secret word is executive. Please select the correct word below. Again, the first secret word is executive.
And Hannah, I'm going to jump in and answer a question that was posed in the chat while we're putting that word in. The question was, what sort of evidence do we need to look at to confirm that the employer has maintained the records as confidential, and how did it protect that methodology? Really, we're looking at three things. We're looking at contractual protections. Do you have NDAs, confidentiality agreements, and similar policies in place, not just with your employees, but other vendors and independent contractors? We're looking at IT access controls. For example, do you have password protections, things of that sort? And we're also looking at physical security, though that we don't use that as much today, but we want to see who has access to the physical files in that space.
Thanks, Emory. So now let's apply the decision matrix to the scenario that we just discussed, the phantom evidence case. So first, let's take a look at business impact. Initially, the company believed the business impact was significant. They thought a key employee had taken sensitive data, patient data, to a competing clinic to create an unfair advantage. But once the facts really came into focus, the actual risk was far more limited. The data in question was outdated, it was anonymized, it was largely irrelevant, and there was no indication that that data was ever actually used to compete against the clinic. The next is legal risk. The claims on paper sounded pretty serious: misappropriation of trade secret information, possible HIPAA implications, and unfair competition. But the legal theories were thin. The data didn't qualify as protected under the applicable statutes, and there was no clear contractual breach. So while the allegations were weighty, the legal footing was weak. And then we have evidence strength, which is where the case really unraveled here. There was little to no investigation before the filing, which, now that we've talked through the steps of proper, due diligence, initial investigation, we know is problematic. And what evidence the company did have simply didn't support the claims it was making. It was mostly assumptions, outdated materials, and a lack of intent for use. So where does this fall in the matrix? You'll see the yellow square highlighted top left. We're looking at low evidence strength, low legal risk, and ultimately limited business impact. This case should have never been escalated the way it was. It's a classic example of why pausing to assess the situation properly before spending other significant resources can save a company from embarrassment and wasted effort.
And this scenario was inspired by a real case we handled. One of the first things we did was sequester the alleged trade secret information by forensically removing it from our clients' devices. That step alone severely undercut the other side's claim that a temporary restraining order or preliminary injunction was necessary, or that our client was actively using the information. These early decisions, what you investigate and how you respond, again, can change the entire trajectory of a case. Scenario 3 is the case of the moonlighting executive. Again, inspired by a real matter we litigated. Picture this: a company's CEO learns that one of their C-suite executives has secretly bought and is now running a competing business. He hasn't resigned. He's still collecting a full executive salary. He's attending internal meetings, signing off on company strategy, and at the same time using confidential business intelligence and client contacts to grow his outside venture. The natural instinct is to act immediately, fire him, file a lawsuit. But in this case, the company took a different approach. Before making a move, they brought in outside legal counsel and took 48 hours to build a complete strategic response. They mapped out possible outcomes, anticipated how the executive and clients might react, structured internal communications to avoid triggering panic or leaks, and quietly prepared for legal escalation. That discipline paid off. When the executive was terminated, the company's message was precise and controlled. And when he almost immediately sued, demanding millions of dollars under his contract, they were ready with a mountain of evidence to show that his termination was for cause and was justified, and that he had forfeited all rights to equity. His lawsuit was dismissed early, but the company didn't stop there. The company successfully sued the executive for his disloyal actions and obtained a favorable resolution that protected the company's business relationships and sent a strong message. This scenario is a textbook example of why early legal engagement matters. If the company had acted on instinct, they could have lost leverage, fumbled the narrative, or handed the executive an advantage. And because multiple high-value customers were caught in the middle, it paid major dividends to pause and focus on how to keep clients out of the dispute. So how can you do that? Well, one thing you can do is you can threaten counterclaims if your clients are named in a lawsuit publicly. Now, some people may be on the line saying, well, there are anti-SLAPP laws. You have to carefully analyze and craft your claims around anti-SLAPP laws, which are laws that essentially prevent you from filing retaliatory lawsuits for someone asserting their legal rights of free speech and asserting claims. Another option that I like is to negotiate redaction. So if they're threatening a lawsuit in advance, I like to go and say, hey, you can file what you want to file, but you have this confidentiality agreement in place that covers this particular conduct. Don't list our client names. Don't list communications you've had with our clients or any other thing that we would consider to be highly confidential. 3, you can have a motion to seal or redact kind of prepared and ready to go. If you know a lawsuit is in the pipeline, you can be prepared to file and ask the court to seal or redact that complaint. And then if all else fails and clients are brought into the action, you can have messaging to customers prepared, because you never want to be in a situation where the client or the customer is learning that they've been named in a lawsuit by Bloomberg law or by receiving a subpoena. You want that messaging to come from you so you can help craft it. In this case, because they paused and planned, they turned that high-risk situation into a controlled strategic win. So let's dive deeper into what that kind of planning looks like in practice. When you're preparing your response, the next step is to step back and evaluate both the legal and business impact of the situation. First, identify possible claims. What legal theories are in play? That might include a breach of contract, breach of fiduciary duty, misappropriation of trade secrets, or tortious interference. If confidential information or client relationships are involved, intellectual property or unfair competition claims may also be options. But identifying the claim is just the starting point. You also need to evaluate the risk, both legal and business. Legally, consider your likelihood of success and any procedural hurdles like arbitration clauses or unfavorable forms, and the potential damages. I've seen many cases where a legal violation can be clearly proven, but there's no meaningful harm to the business. That simply makes it difficult to justify litigation, especially if the cost or distraction outweighs the potential benefit. On the business side, ask, will this get public attention? Could it impact investor confidence or employee morale? Will customers find out? The possibility of being named in litigation can often make your customers uncomfortable enough to end the relationship, simply to distance themselves from the conflict. You don't want that. And even if they're not named, they may not want to be caught in the crossfire. Oftentimes what I see is we have an executive who has great relationships with the clients. The client also has a great relationship with the company, and they'll be torn into the middle, and they don't want to be involved in that sort of a situation. And you certainly don't want a situation where you're making them choose between the executive and you. You want to put the litigation on your terms so that you can knock the former employee out of consideration for obtaining that client's business to begin with. Sometimes you may have a strong legal position, but the business risk makes litigation a poor choice. Other times the opposite is true, and acting decisively is worth the risk. Sometimes you might actually be contractually required to take action. For example, if your client's trade secret information is stolen by your employee, you might be required under your contract with that client to take action to recover their information, or to at least notify your client that their information has been taken. Overall, the best strategy happens when you consider both legal and business strategies side by side before making your next move.
Emory, while we're talking about, identifying claims and risks, this seems like a good idea to address another question that we have in the chat, which is, how do you determine whether to file a lawsuit in federal court, under a federal statute, or under state law, or both?
Sure. I can provide some comment there. It really is case by case, so this is not a helpful answer. It can be case by case, and it depends on the particular facts and the particular law involved, the particular jurisdiction. Do you have a jurisdiction that's employee friendly, employer friendly? There are a lot of different analysis points that go into that, so there's really no particular roadmap I would feel comfortable saying every time you're going to go in federal court on these types of claims. I know personally, for example, I litigate in Michigan a lot. I love going to Michigan court. In Illinois, where I am, I love going to federal court here because the courts and the laws are a little bit more employer friendly. But it's really a case by case situation. So let's take the moonlighting executive scenario and map it onto the matrix. Start with legal risk and evidence strength, which are the rows on the left. In this case, both were high. The company had strong evidence of disloyal conduct, conflicting financial interests, client interference, and potential misuse of confidential information. There were also clear contractual obligations that had been violated by that executive's moonlighting activities. Business impact, the columns on the top, that was also significant. We had a senior leader deeply embedded in strategy and client relationships. His conduct risked undermining employee trust, damaging client retention, and exposing the company to future competitive harm. So we're looking at a situation that falls squarely in the bottom right quadrant: high legal risk and high business impact. That's your green zone, the case where escalation is not just justified, it's necessary. But escalation doesn't mean chaos. What this company did was right. It paired immediate action with a thoughtful plan. They preserved leverage, controlled messaging, and anticipated retaliation. And as a result, they stayed in control of both the legal and business narrative. So this is a great example of how applying the matrix early, before emotions take over, allows you to quickly and strategically act when it matters most.
So our fourth scenario today is the case of the poached playbook. This scenario was inspired by another matter that we litigated another matter that we litigated that was brought in after the initial response went off course. This is something we've seen happen all too often. A company was preparing to close a major acquisition. It was the kind of deal that would solidify the company's presence in a key market. But just before closing, a competitor moved quietly and systematically. They hired away nearly the entire workforce of the target company. Along with those employees went critical product designs, development roadmaps, and the knowledge that made the acquisition valuable in the first place. The acquiring company was blindsided. Under pressure, they quickly hired a large law firm with a reputation for aggressive litigation. The firm quickly filed a lawsuit against the competitor, accusing them of orchestrating that raid. But here's what they did not do. They did not thoroughly investigate the employees who left. They did not request access to personal devices. They did not demand interviews or written statements. And they did not take any legal action against the employees directly. The strategy focused entirely on the competitor with the assumption that going after the architect of the raid would be enough. But without going through the individuals first, the evidence was incomplete. In cases like this, it is often worth pursuing claims against the employees, even if they are not deep-pocketed and even if there is some reputational risk to being known as a company that does sue its employees. Doing so helps strengthen leverage, fill in evidentiary gaps, and build a more compelling narrative, all of which are key in high-stakes matters like these. By the time new counsel was brought in, key windows for early action had already closed. The legal team had to pivot the case strategy, bring in technical experts, and work to rebuild momentum. But it was far more difficult and far more expensive than it needed to be. The lesson here is that speed is not a substitute for precision. If you move fast but skip the foundational work, your legal position may look strong on paper but collapse under pressure. So what happens when you need to take action but you're not ready or you're not sure if it makes sense to file a lawsuit? This is where your pre-suit strategy becomes critical. Again, the goal is to be surgical. You want to balance your legal options with business realities and avoid overreacting in either direction. You want to use that scalpel. If you move too aggressively, you risk making procedural mistakes, generating negative publicity, or escalating really just before you're ready. On the other hand, if you wait too long or you play it too safe, you may lose leverage or even waive legal rights. Some of the most effective pressure points happen before a lawsuit is ever filed. One option here is a demand letter. This puts the employee and often that employee's new employer on notice that you're represented and you're tracking the situation. It shows you're serious and it can trigger a resolution or dialogue even without formal litigation. Another option is making a police report or a criminal referral. This is not the right fit for every case, but when data theft, unauthorized access, or physical device misuse is involved, a police report can increase pressure and create a parallel record beyond that sort of initial due diligence and investigation that we've been discussing. A third option, though technically not pre-suit, is seeking a preliminary injunction. This requires filing a lawsuit, but it's often the first major move once litigation begins. A motion for a preliminary injunction can lead to a hearing that puts pressure on the employee quickly, while giving you an opportunity to control the narrative and shape the evidentiary record. Whatever route you take, it's important to think through who your witnesses would be, what documents you have to support your claims, and how much disruption your business is prepared to manage. You do not always need to file a lawsuit right away, and that can be very disruptive. But when you choose to act, the action should be deliberate, defensible, and backed by clear goals. So let's map the poach playbook scenario onto our matrix, starting with legal risk and evidence. This case involved very serious allegations. There was reason to believe that a competitor had orchestrated a large-scale raid of employees and that key confidential materials had been taken by those employees in the process. However, early missteps in evidence preservation and investigation weakened the company's ability to prove those claims. So while the legal risk was high, the evidence strength was not where it needed to be, especially at the outset. On the business impact side, this was obviously major. The company lost the team it was acquiring, along with the core value of this big deal. Clients were at risk, internal confidence was shaken, and the deal itself unraveled. That puts the situation in the top right quadrant, high business impact, but compromised evidence. When you're in this space, you need to act, but your strategy needs to account for the gaps and proof. That might mean pursuing informal action, the options we talked about, issuing demand letters or leveraging other pre-suit pressure points while you work on building your case. And in hindsight, this scenario is one that could have landed in the bottom right quadrant, where full escalation would have been appropriate if the company had focused more on evidence early. It's a good reminder that missteps in the first few days can change not just the strength of your position, but where your case falls overall in this framework and the kind of response that you're going to take.
Thanks, Hannah. To build on that, when you are confident that a serious violation has occurred, but you're light on evidence, you still have options. One approach is to negotiate an out-of-court agreement for limited pre-suit discovery. Another is to file initial papers and request expedited discovery from the court. Both options can give you fast access to critical evidence like devices or communications before anyone has had a chance to destroy or lose it. Timing is everything. That extra step, again, can change the outcome. Let me give you an example. In the final case we'll discuss today, pre-litigation discovery was the turning point. The scenario involved a CEO who orchestrated a scheme to make himself more than $100 million at the company's expense. Over a year before he resigned, he began quietly laying the groundwork. He held off-the-record meetings. He coordinated with trusted insiders. He had quiet conversations with vendors and partners, all of which was designed to benefit a direct competitor. He planned to take over as CEO of that competitor and take the majority of his compensation in equity. Through his corporate espionage, he then planned to massively boost the value of that equity. And by the time he finally gave notice and resigned, the fuse on his plan had already been lit. After his departure, key employees quickly followed. Within weeks, so did valuable business relationships worth billions of dollars in revenue. He had restrictive covenants, but he was in California, and we all know that such agreements are typically unenforceable in California. And to make things worse, very little evidence of misconduct was found on the company's systems. The legal advice the company initially received was nearly unanimous. This is California. You don't have any evidence of theft. There's nothing you can do. Just move on. But we did not move on. We negotiated access to the CEOs and competitors' devices and systems for forensic review in exchange for agreeing not to seek a temporary restraining order. In response to our cease and desist letter, the competitor had already looked and found nothing. They were confident that a forensic expert would find nothing as well, so they viewed it as a win-win. They were wrong. While a significant amount of the data had been deleted, the forensic expert was able to recover a substantial portion. See, what they didn't understand was that the deleted data was not immediately erased. The information remained recoverable until the disk space was actually overwritten by new data. So by acting quickly, we were able to recover information before it was overwritten and permanently lost. That was a big win. And there's really two lessons from this. First and foremost, and I see this every day, just because your employee, your new hire, is making representations to you, I haven't stolen anything, I haven't done anything wrong or had any improper conduct, you can't take that as absolute fact. You have to do your own diligence and investigate to see, is this actually going to hold up if my company is brought into a lawsuit because of something that this person did? And then number two, when the stakes are high, the answer is not always in the obvious playbook. You need to act quickly, look deeper, and be willing to push where others would not. If I had $1 for every time opposing counsel scoffed at me for relying on mere suspicious timing to seek a full forensic review, I'd probably be on a yacht in Monaco right now. But when the impact is high enough and there's good reason to be suspicious, so here where we have an executive leaving and everyone is leaving immediately after him, you have to follow up on that suspicion. So before we wrap the scenarios, let's take a moment to talk about some of the most common pitfalls we see when companies respond to serious employee misconduct. First, optics. Just because you are legally justified in taking a particular action does not mean it is the smartest move from a reputational standpoint. You have to consider how your actions might be viewed by a court, your board, your employees, or the public. Second, cost. Some strategies look great on paper, but are not feasible in practice. You have to consider whether you're prepared to absorb the legal fees, expert costs, and internal disruption that come with litigation. For example, in that scenario, hiring forensic experts who are experts at that niche area of recovering deleted data can be very costly, especially when you're dealing with dozens of employees, dozens of devices. You have to make sure the juice is worth the squeeze. Third, availability of resources. That includes your internal bandwidth, but also access to the right outside counsel and experts. Again, scenario 4 was a great example. We had to rely heavily on a trusted forensic firm because the departing CEO had deleted a significant amount of information. Without the right partner, that case might have stalled very early on. Fourth, legal limitations. Jurisdiction matters. Some states like California are hostile to enforcing non-competes and other restrictive covenants. Other limitations also matter. For example, indemnification clauses, form selection clauses, or contractual carve-outs that narrow your options. I'd even had a case where we had an indemnification clause that required us to pay the executive's legal fees for defending against our lawsuit against that executive. Hopefully you don't have an indemnification clauses like that, but you have to consider the full scope of your restrictions. And finally, be honest with yourself. Is the limitation real or is it just perceived? And if it's real, how significant is that limitation to your case? We saw that in scenario 4. California law and the facts made protecting the company difficult, but not impossible. We had to move on suspicion alone. But we also saw the flip side in scenario 1, where the employer reacted too quickly and ended up locked into expensive litigation with no clear payoff. The point here is you should not give up your options. You should not give up before your options are fully explored. But you also shouldn't act until you've really fully explored every particular aspect. So you have to think creatively, assess the risk and resources, and then move forward with a clear strategy that fits your unique situation. So let's take a moment to apply the matrix to our final scenario. But rather than just telling you where we ended up, I want to hear from you. So imagine it's the day the CEO gives notice. Shortly thereafter, other senior leaders begin leaving to join the same company as the CEO. Then your customers begin leaving. You have no evidence of misconduct and believe you can't enforce your restrictive covenants, but your board is still highly suspicious of this activity. At that point in time, where would you place this on the matrix? Would you say A, do not escalate, B, consider informal action, C, escalate cautiously, or D, escalate immediately?
All right, we'll give some time to select your response.
While we're waiting, I see a question. Do you think Astronomer handled the CEO correctly, or would you have done it differently? You know, I'm going to respectfully decline to provide my opinion on that. But Hannah, if you'd like to, feel free.
Well, that seems like it might be a good time for us to take a look at our poll results. So it looks like the majority of you selected escalate cautiously. We have some others leaning towards considering informal action or even escalating immediately. So that's what we think really makes this a great scenario to analyze. At the moment the CEO gave notice, C would probably be the correct response. This case would have landed in the bottom left quadrant, so high legal risk, high business impact, but limited evidence. That meant the company needed to move carefully, not by overreacting, but by preserving options and gathering facts. And that's what happened here. Through expedited discovery, deleted materials were recovered, and the story really came into focus from there. Once that happened, the case moved firmly into the bottom right quadrant, escalate immediately. So that was option D on your poll. So the key takeaway here is really that the matrix isn't fixed. It reflects what you know right now. Strong early decisions, especially around timing, discovery, and investigation, can shift your position and open the door to more effective legal action. And of course, matrix isn't definitive. Every case turns on its own facts. That's part of what Emory was discussing earlier when talking about whether or not you might file in state or federal court. But ultimately, the matrix offers a helpful framework to organize risk and guide your early thinking. So let's wrap up and just discuss kind of the main question that we've been reviewing today, which is when should you escalate an issue of employee disloyalty? So we're going to provide some tips on what you should do when one of those issues arises. The First is revisit the decision matrix. That will remind you of the necessary legal, financial, competitive, and cultural considerations. Think about those green light triggers and red light triggers in that matrix. So when you have high business risk or high legal risk or potentially low evidence, what are those moments where you either definitely should move forward or definitely shouldn't? We would also encourage you to think about when your outside counsel adds strategic value to the kind of response that you're going to take to the issue of employee disloyalty. So think about engaging outside counsel early, like when you're negotiating those agreements that we've talked about, so that those are as advantageous to your company as possible. Think about selecting a firm where your counsel for employee issues can also work hand in hand with IP experts and other outside experts, like we think we do a great job of doing here at Thompson Coburn. So before we move on to discuss questions that have come up today, let's pause for the second secret word. Today's second secret word is matrix. Please select the correct word below. Again, the second secret word is matrix. All right, so we have covered a lot of ground today, and we'd like to answer a few questions. So we have some that were solicited ahead of time and also some that have come up in the chat today. So let's start with a question that I'll pose to Emory. So how do we handle reputational risk when suing employees directly, which is something that we said a company kind of failed to do in one of the earlier scenarios we discussed today?
Sure, and that's an important question because you never want to win the battle but lose the war. The battle being the dispute and the war being your overall business. In my experience, focusing on retribution and revenge, which happens more than you might think, is a recipe for reputational harm. Focusing on protecting the business's legitimate interests, however, rarely results in true reputational harm. This is particularly true if you control the public narrative by being cautious with the way you frame any allegations in a public filing or press release, to focus again on protecting the business instead of demonizing the employee. And I'll also say, oftentimes, counsel can get overzealous in how much information they're including in complaints, and give you a little bit more information than necessary, which, as the defense side, gives me more opportunities to find reasons to say, hey, this plaintiff has pleaded themselves out of court because they made XYZ statements. So again, sticking to the particular legitimate interest you're trying to protect and the particular elements you need to plead is a great way to protect yourself from reputational harm. But that can be tough to do, especially when you have a stakeholder that is emotionally involved, which happens often. So I'm going to kick it back to you, Hannah. How do you handle, for example, a CEO who's taking an employee's actions personally?
Yeah, I'm happy to take that, Emory. It's common and understandable that key stakeholders are going to take it personally when employees cross the line in the really serious ways that we've discussed today. When that happens, I think it's really important to focus on the long game. So sort of, you don't want to win the battle but lose the war, kind of like we've talked about. And I think this is a good opportunity to emphasize for that key stakeholder, whether it's CEOs, founders, other execs, some of the tools that we've talked about today in the sort of counsel toolkit. So pull out that decision matrix. Think about the other strategic filters like timing, leverage, forum, visibility, which you were just touching on. And that might help your CEO consider the disloyalty issue from a more objective perspective. If you're dealing with an issue like this right now, that could also be a great time to sort of strategically engage your in-house counsel or your outside counsel to talk to that stakeholder that's really feeling emotionally invested in the issue. That can also be a sort of moderating force when emotions are really high. Another question that we've had come through is, I'll flip this back to you, Emory. So how can an in-house legal team differentiate between interests that are important to the company versus those that are legally protectable? And do you see them like as always the same?
Sure. And that is a big question that I think is not considered enough. No, those are not always the same. There are many things that a company might view as a valuable piece of information or something that's valuable that's not protectable in court. Courts, of course, typically protect things like trade secrets, information that is confidential under an agreement, business relationships, goodwill that you've built in the market. Courts don't typically protect things that your competitors can readily learn or obtain through minimal effort, or things that aren't valuable to anyone but you, right? Likewise, courts often look at your actions to determine whether to protect your interests, which was one of the questions we got earlier. If you're claiming something, for example, as a trade secret, but you're not adequately protecting it, why would a court take action to protect it? If you're claiming that you need emergency court relief, but you sat on your hands for weeks after learning of employee disloyalty, why would a court grant you emergency relief? Whether something is actually protectable is exactly why we asked in the matrix whether we actually have claims available. So it's built in there to look at it and say, is this protectable information? I think another question that we get often is about relying on outside experts. I'm concerned that an outside expert, like an IT consultant, for example, won't know the facts in business as well as an insider will. When and why would an outside expert truly be necessary? Hannah?
So I think that's a great question. And of course, like a lot of what we've been discussing today, it's going to depend on the particular facts of the case. But for as much as your sort of in-house teams, your in-house legal team, your in-house IT team might know about a particular situation, there can be some really complex technical factors at play in cases like these. So it's important to think about, does your in-house IT team regularly access the kinds of information about, when somebody's accessing files or deleting files from a particular company device? You're going to need information like that when you're pursuing cases like this. If you think, for instance, that protected information has been taken off of company devices, and not to say that your in-house information technology team isn't a team of experts when it comes to day-to-day operations and the kinds of logistics that your employees are normally dealing with, but to get that sort of deeper level of evidence and to help you decide whether or not you have the kind of evidence that would support escalating issues further, that's when you may need to consider consulting with experts and consulting with experts early on.
So another question I see is, can't you internally escalate to get the evidence you need, even if you may pursue informal action? And the answer is absolutely. And oftentimes you should. And one of the reasons you should is because you may find yourself in a situation in the future where you need to show that in this particular instance, you took reasonable steps to investigate what happened. You also preserve the information as well, but you took reasonable steps. And in this particular situation, you found that it did not warrant escalating it to the next level. What could happen if you don't take those extra steps internally to at least look at what happened is in the future, you'll undercut other claims if a similar situation arises. And the court will say, well, clearly in this prior situation, you haven't viewed this information or this particular activity as overly concerning. Why should the court itself take action and consider this concerning now when historically you haven't done so? And you can point and say, well, we investigated this in this situation. and we found XYZ factors did not warrant escalating, but this scenario is distinguished for this particular reason.
So that's probably all the time we have in terms of addressing questions during today's session, but we'll reach out for any sort of pending questions separately. So thank you for attending today. Please contact us directly. Our contact information is there on the slideshow to get a reference guide that'll be put together based on today's presentation. You'll also see some links on that final slide to the other facets of our human resources practice here at Thompson-Coburn that we would encourage you to check out. So thank you again for participating in our webinar. Please complete and submit the survey that will display at the conclusion of the webinar. Thank you.